Hi there, I'm Gary Ray Fraley. I'm a California State Bar Certified Bankruptcy Law Specialist in Sacramento, California. A very common question I get from clients: can I save my business using Chapter 11 reorganization, Chapter 13 bankruptcy? Very common. And my answer is, it depends. If you have a business that cannot support its regular ongoing expenses, the answer is probably going to be no. If you have one that can, then the answer is very different. One of the things that I've seen out there, because of COVID pandemic, I have clients that they come in, they were open, then they were ordered closed, then they were allowed to open again, and then they were closed, then they're allowed to do their services out in the parking lot or whatever. This has been total chaos and a disaster for untold small businesses. And a lot of them are too far down. They're never going to come back. 1 in 6 small businesses that had to close will never reopen, or if they reopen, will not make it a year before they fail because of the amount of the debt load on it. Now, those that can be salvaged, and that will depend on whether or not there's funds enough to meet the minimum operating requirements. They can be salvaged using 3 different tools in bankruptcy. One is Chapter 11, straight bankruptcy. We'll briefly talk about it, very briefly, but we'll come back to it. The other is the Chapter 11 Small Business Reorganization Act that went into effect February 19 of 2020, right before the COVID hit. And the third is Chapter 13 Debt Reorganization. Now I'm going to go to the third one first. The third one, Chapter 13, can be used. You can use it to buy time and extend out the time to catch up on back rent, a few months, a year, sometimes more if we can negotiate it. You can use it to control other debts. A lot of my businesses that come in, they've incurred a lot of credit card debt trying to keep the business open, pay employees. They've used up their payroll protection plan funds and still just don't have what they need to get there. If that can be turned around, we can use Chapter 13, but only if your business is what's called a sole proprietorship. That's a business that an individual or a husband and wife may have, that they're John and Mary Smith doing businesses, Acme Machine Company or Little Tokyo Restaurant or whatever. A DBA, you and the business are the same thing, and it allows you to use it to control all of your debts and to help your business get back on its feet. It is complicated, but it is the closest to anything that's going to help you where you have absolute control over the creditors. It, like I say, can help you catch up on things. You can even have a business and keep it running and get rid of all of your general unsecured debts and pay your taxes, pay off your car, cure a mortgage. All of that can be done in a single package, Chapter 13. It is the least expensive way to salvage a business. If it's not salvageable, then we go on and we look at Chapter 7 and other options. But if you can get control of the debts, which we can in a Chapter 13, that may well give you the breathing space to rebuild your business, especially if we don't have to pay a ton of other debts out there, credit cards, signature loans, SBA loans to the extent that they're not secured, that to the extent they don't have a lien on something. All of these can be done. Now, and that's the cheapest, simplest way to go. Now, if you cannot do that, let's say you have a business that exceeds the limits for a Chapter 13. By the way, the cap in terms of the amount that you can have in debt and use Chapter 13 is $419,275 of general unsecured debt. That's basically debt that doesn't have a lien on something. If you got a car payment, that's got a lien on the car. If you got a house payment, that's got a lien on the house. Those are called secured debts. Other debts, unsecured, that's what counts for that. Most people are going to be under that limit. The other limit is $1,287,850 in, $1,257,850. That's what I get for not having my glasses on. That's what's called secured debt. That's the mortgage. That's the secured lien on the car. That's the SBA loan to the extent of the value of the assets of the business they took a lien in. Rarely, unless I'm dealing with somebody who has multiple houses or consumer, non-consumer property, business properties, rarely do I have people that exceed that. Let's say you can't use that, and we'll go back. Then we have two tools. One is the Chapter 11 bankruptcy reorganization. It is complicated, it is very expensive, and it's great if you've got a multi-million-dollar company, but if you're not a multi-million-dollar company, you can't afford, $30,000, $40,000, $50,000, you're not going to get a good attorney to represent you in Chapter 11. Here's the good news, though. There was the Small Business Reorganization Act that went into effect February 19 of 2020, right before COVID. And it will apply. And even if you have what would have been a 13, but you fail the debt limits, we can use this. This reorganization doesn't have the creditors on its back. They cannot propose a plan. There's no creditors committee. We can set our own plan. We don't have to pay a charge every month to the United States Trustee's Office for them to have somebody who wants to knock our reorganization down. It isn't cheap, just filing. The court filing fee is over $1,700. So it isn't going to be cheap, but you're looking at more in the range for any competent attorney, probably $5,000 to $10,000 upfront, or part of it in a trust account, which is typically how it goes. It's very expedited. We don't have to have creditors vote on the thing. There is a trustee from the U.S. Trustee's Office, but their purpose is totally different than the normal Chapter 11 trustee. This trustee, their job is to help you succeed, to help you in putting together a viable plan. And this makes a huge difference. There are a lot of restaurants. In fact, I have a attorney friend of mine down in Southern California that she has 10 restaurants that she's filing Small Business Reorganization Act for. And there are a lot of them out there, and you may be one of those. Don't give up hope. See a good attorney, see somebody that knows what they're doing. Given the newness of the Sub 5 Small Business Reorganization Act, there's been a relatively small number of those cases filed out there, but they are going to explode, and in a good way. Attorney out there, if they know what they're doing, they're going to make every effort to save your business for you. And if it can't be saved, they will make every effort to see to it that you come out in as good a condition as is possible. Don't try to do this yourself. It will not work. 100% guaranteed. You probably should, not probably, you should, scratch probably, you should go find a state bar certified bankruptcy law specialist. There's only about 200 in the state of California. You can look up at the state bar, you can take a look at it, look for specialists, and it'll take you to a page. And you can look up bankruptcy for your county, and it'll give you names. Don't limit yourself to just who's in your county, and maybe nobody's in your county in some of these smaller ones. Don't go with somebody just because they say they specialize in bankruptcy. Anybody can say that, but very few people can say, I am California State Bar certified. The State Bar says I'm a specialist. Use the best. It is always cheaper and more successful in the long run. There's a lot more detail to any of these things, of course, and you'll need to sit down with an attorney. I would ask if this has been of use to you and helpful, please give it a thumbs up. And if you would, I would be delighted if you'd share it, or also join my subscription to my YouTube channel so that you can get more of these videos in the future. Thank you again. You have a good day. Stay safe.